And without going into the contents, tell me if you recognize that document.
Yes, this text message that Alex sent to me and Christy on September 26, when he was in 2021, when he was in rehab, is my understanding.
All right. Your Honor, this time I'd offer States 441 into evidence, I believe without objection.
No objection.
Submitted without objection.
No additional objection. Your Honor, I apologize. We do have the 403 objection, and subject to the court prior ruling on this.
I haven't seen the exhibit. I don't.
Yes, sir.
Ladies and gentlemen, I'll have you go to the jury room for a break. Please do not discuss the case. Yes, sir, Mr. Griffin.
Just preserving our prior objections on 404B evidence under 404B and 403. And this, it's nothing new. I just forgot to state no additional objections than what we've already had in this line of testimony, which is this is the same line of testimony of financial misconduct. That's all.
Mr. Waters.
And I just clarified, I think, with the defense counsel that he was not adding a specific 403 objection to that. It's just the prior objection. However, this is a text from the defendant to this witness in this particular instance. Certainly, it can be read, and there's no hearsay issue because obviously it's a statement of a party opponent, and it certainly also is relevant because it can certainly be read in the nature of an admission to the various things that are at issue in these particular proceedings. And for that reason, there's certainly the probative value of an admission is certainly, I would argue, is the probative value of that is not substantially outweighed by the danger of any unfair prejudice.
It introduces another issue, the issue of drug use, and I think the witness testified that he was in rehab. Is that what you said? That he was in rehab and sent an email, and just want to be clear from the defense, the part of it, of the testimony that establishes through this witness that he was in rehab, that is not a basis for your objection?
We do have, yes, we do object to evidence of his drug use and to be included in this, and we would ask that that document be redacted to the extent it references rehab at this time.
It doesn't specifically mention drug use. So, have you all review the exhibit and tell me if you have no objection based on the fact that he sent it while in rehab, then it's admissible as far as your prior bad acts objection.
We don't have any additional objections, Your Honor. We would, because this does raise an additional character issue, asked of the court. We ask that the court give, additional limiting instruction at some point in time.
How does the character in that he saying he's getting better, or what part addresses character?
Certainly he says, I'm getting better every day, and I mean, it's clear from that he's in rehab. I mean, that's all.
All right, Mr. Waters.
Your Honor, I mean, he doesn't expressly say that. I would point out that the issue of pills has already come up a few times in this trial. I'm not trying to go there, but it is, when we talk about 404 and res geste, it is kind of part and parcel of a lot of things. I mean, even the defense has examined, I believe, Ms. Seckinger on the issue of pills. And on top of that, we had Chris Wilson, who testified in camera, who will also testify here today. One of the things he says when he had that confrontation with the defendant on the the afternoon, I believe, of September 4th, that the defendant said, yeah, I've been stealing money and I've been hooked on pills for a while. So this is a bridge I think we have to cross at some point. The state is not trying to gild the lily with that, but at least with these various witnesses, it is part of what they're being said. As far as that specific exhibit, though, Your Honor, there's no express reference to drugs or anything like that, and it certainly is in the nature of admission. And again, I think for that reason, it's very probative and very relevant and admissible for that reason.
Well, my concern, obviously, is that we do not, or that I do not allow testimony involving these admissions to bleed so far into the character 403 that it has the effect of undoing the 404 analysis. A lot of testimony has come in unobjected to that touches upon the defendant's character. That's why I want to be clear on what the objection is.
Your Honor, just from the state's perspective, we are trying to, walk that line. I mean, there's a lot of the financial stuff we're not even seeking to admit. I think that we've limited it to things that had that connection that we discussed in camera. So, I'm not trying to gild the lily.
I'm not sure what that means.
That's a phrase I learned from Chief Justice Toll over the years. I guess that means piling on, I guess, is a way to do that. And again, I don't have, we recognize the situation we're in and trying obviously not to get out over our skis from what the admissibility of that the court has already ruled on.
All right. I'll ponder it while we take our break, and we'll be in recess for about 15 minutes. Ma'am, you may step down. Do not discuss your testimony.